Hello, so we're going to be speaking about the Administrative Review Tribunal that started from the 14th of October. And I know there is a lot of questions around what are the main differences, why they decided to make these changes. And yeah, we're going to speak a little bit about this.
Yeah, definitely. So new Administrative Review Tribunal is now in session, and the old AAT has been abolished. Now, this has had quite a significant impact on the way that appeals or review processes are going to be handled. And I thought today we'll just do a very short video and cover a few of the key points. You know, we could probably spend an hour talking about the differences, but I think let's just give everyone a few key points in terms of what's changed.
So one of the main differences is the three divisions the Administrative Review Tribunal is composed of: Migration, General Division, and Protection Division. What are the differences around this?
Well, I think the main difference, one, is that now we have a separate protection division, and that's something that we didn't have under the old AAT. And it will allow the ART to focus just on protection cases. Now, all of your migration cases, so for example, visa refusals, general cancellations will continue to go to the migration division, and then your general division will stay for character and citizenship.
Yeah, do you think this is going to expedite the process for those migration cases, like visa refusals and stuff like that?
Yeah, it's one of the questions I think that everyone will want to know, whether it's going to make it a bit more efficient. I hope so. I think it's a bit early to tell, but the fact that the Review Tribunal recognises that these areas of law are quite different, I do think that it's going to make sense that protection cases have their own division, because they do make quite a significant number of the cases. So hopefully we'll see a much faster turnaround.
Yeah. Okay, now in terms of starting the process, the review process, it is understood that the registrar has expanded powers, meaning that where before they needed the intervention of the member,
yes,
now they won't need this intervention. What does that mean?
Well, Juan, what it means is that now the registrar is able to make certain decisions on the applications. Probably the most obvious one would be where the matter doesn't need to go to a hearing. So say, for example, an application gets refused because someone didn't upload a police check or they haven't done their health checks. There really is no need for it to go to the hearing. If someone does the health check and they meet the requirements, the registrar can just order the decision to be made without the hearing. But what's also important is that if, let's say, there's an application made and it just lacks documentation, the registrar can also determine that this application is being used to potentially, buy time or just being lodged without any merits to it. So they are going to be able to make those decisions without the case actually going to a member, and that's one of the key differences. So it'll be interesting to see whether, again, it will speed up the process.
Yeah, and what's the main difference between the registrar and a member? Because there seems to be if the registrar is going to be making some decisions, then what's the main difference between these two figures?
Well, that's a good question as well. So when you look, and without getting too technical, but when you look at the actual sets of powers, so now every single individual has almost like a job description, if you want to say that. And within the registrar, as part of their job description, they can make simple decisions. When I say simple, decisions that don't require much of an input from the applicant. So the application either meets the criteria or it doesn't. Say, for example, if you lodge an application outside the processing time, it doesn't need to go to a member now, so that the member can determine whether the application is made within 21 days or 22 days. So it will speed things up, whereas members will now focus on more of your contentious issues. So, for example, let's say if there's a student visa application refused based on genuine study, that will need to go to a member, because the member will need to hear oral evidence and make that decision. So it will free up quite a significant amount of time, in my view.
Absolutely. And that brings me to the next point that I wanted to discuss, because you just said it, like the registrar will be able to determine when someone is trying to buy time, which means that part of buying time, going to the review process just to buy time, it seems to be vanishing, or seems to be like that they're targeting that point to be caught and to be reduced. Well, expand on that, please.
Yeah. Look, I think we've talked about it quite a lot in our podcast before about not lodging applications for the sake of buying time, because it always bites you in the behind, so to speak, when you do that. But now it's actually explicit in the Tribunal Act, which states that if the application looks like it was lodged to buy time, it'll be dismissed. So what might that application look like? No documents uploaded, just a copy of the refusal, no submission, no real evidence as to why the application's lodged. So think of it this way: if you were to pick up an application and you don't really know why it was lodged, and all you have is just a fee and a form, those sort of applications would be dismissed because all you have in front of you is an application form. So that needs to be taken into consideration, and I think it's important to acknowledge that not everyone's case should be going to the review. There might be a genuine decision where the person just doesn't meet the requirements.
Yeah, absolutely. And that brings me to the last point of this. I think it's worth it to seek early advice, and then determine what sort of documentation and what sort of submission needs to be presented right at the beginning, so the registrar can determine, yes, this is valid, can go ahead, and there is a valid proposition on why this refusal shouldn't have been done.
Yeah, I completely agree with you, Juan. I think it's going to be exceptionally difficult to be handling cases at the last minute. So if someone approaches you, say on day 20, to lodge the application within 24 hours, is going to be exceptionally difficult. It was possible before, where you just sort of upload the form and pay the fee, and then you provide the submissions within a reasonable period of time. But now the Act prevents that, so the onus is on the applicant either to seek advice if they don't know what they're doing, or to lodge the application in time. That's why you're given statutory limit, whether it's 21 days or 28 days. You really shouldn't be leaving the application to the last minute. So I think the advice is to seek help as soon as possible. If you can't get professional help, it is possible to call the ART. They might be able to assist, but the sooner you do it, the better.
So definitely the recommendation is to prepare a submission, not just a simple cover letter, but a submission where you're going to state the reasons why you believe the refusal or the matter that you're bringing to the ART should be heard.
Yeah, 100%. So it'll be sort of similar to how courts operate. You can't just lodge an application with the High Court and say, we'll provide you with documents later. There are certain directions that you have to follow. So whilst ART is not a court, it does follow that similar procedure, because what happens is if you don't and you let people lodge applications, this is why we have waiting periods of 2 and 3 years. So hopefully, I think it'll be different, but I think it's going to be quite a more structured process, and we'll see decisions made quite quickly.